Thank you, everyone. Please be seated. Old room, old chairs. Welcome to an oral argument tonight in the esteemed courtroom of the Iowa State Capitol, where our court was housed for many years until about 20 years ago. It's been that long since these walls have heard an oral argument, and so I speak, I know, on behalf of our full court. This is pretty cool. So we appreciate everyone showing up, and for those of you who could not join us in person, who are live streaming wherever you may be in Iowa or in the country or in this building, welcome. Tonight, we're going to have an opportunity to, of course, ask questions like we always do from the bench during the oral argument. Be patient with us. We're using a different system, but we think we're doing it right. We're supposed to remember to turn our mics off. And that's what my biggest fear is, that I won't. So tonight, we're going to hear the case of Summit Carbon Solutions versus Kent Kasischke. Not sure if I pronounced it correctly. And Mr. Jorde, on behalf of Mr. Kasischke, you may proceed.
And its progeny, Lucas, in the cases before it. So in this instance, it doesn't really matter if it's a question of facial versus as applied. If there's a taking, the statute's unconstitutional, period, because it doesn't provide for just compensation. It doesn't provide for due process of law or a jury trial to get to just compensation. So that's the unconstitutional piece. The background principle argument, which are narrow exceptions in Cedar Point, do not fit into what this entity wants to do or the other 47(9.15) entities would do. So it's unconstitutional on its face. The background principles don't apply because the background principles are very narrow. They are for imminent public danger. They are for a disaster such as a public nuisance of a flood where you need to put sandbags on someone's property in an emergency to save the town. They are things that are so steeped in the legal history of the particular state and in the mindset of a landowner that a landowner knows those types of things are background restrictions on title.
Are you making a distinction between the right of entry to survey generally and the right of entry to survey for a pipeline?
Well, I'm just here on this case, and the statute is particular only to an interstate hazardous liquid pipeline company. So that's the only argument I'm making.
Are you contesting that Iowa has had surveying statutes since the time of its founding that allowed different entities, whether it's the state or other people building toll roads, bridges, et cetera, the right of entry just for the limited purpose of conducting a survey? Are you denying that?
I don't deny the fact that pre-condemnation surveys have previously been exercised in the state of Iowa. I certainly don't deny that.
Well, then why wouldn't that be one of the narrow traditional exceptions that Chief Justice Roberts wrote about in Cedar Point?
Well, Chief Justice didn't write about those type of background principles. There's a single sentence that talks about potentially access to private property, but then it goes on to talk about criminal aspects, fleeing felon, public nuisance. We don't get anywhere in the realm of a convenience entry, a convenience invasion to kick the tires, so to speak. And many of the examples that Summit actually makes in their brief are about public entities, the Department of Roads, entities that are already conferred with and by their very existence have eminent domain. You cannot have a pre-condemnation survey exercised by an entity that does not have condemnation and isn't vested with the power of eminent domain. So the state of Iowa is vested as a government with the power of eminent domain. There is no question. So if they go out and survey for pre-condemnation, they are already a condemnor. When Summit in September 2022 filed this petition for injunction, they weren't a condemnor. So they want to go out and kick the tires on a car that they legally can't purchase and do so on a dealership that they don't have the right to access. It's completely different from the examples, frankly, that they cite in their brief.
What about utilities? They're private entities. What would happen to their ability to conduct a survey to see where to put a power line if we agreed with the outcome you seek in this case?
If you agree with the invalidation of 479B 1.5, there will be no effect on those entities because they're not covered entities. This is such a narrow statute that the sky will not fall if you go with landowners on this particular case.
So, but what is the legal distinction you're drawing then? Are you saying that there's an issue with giving condemnation power to this particular company? Or is it just the pre-condemnation right of entry generally? I guess I'm not sure where you fall on that.
I see where you're going. I appreciate that distinction. So pre-condemnation is something that can occur if that entity has condemnation rights. If they are not vested with condemnation rights, certainly you can't do a pre-condemnation activity if you can't even condemn. And so the remedy is very simple. If you are truly a condemner, you can condemn an easement for access for entry at any time. Just exercise your rights. We're talking about the convenience of a for-profit private company in this instance to just go out and look around on the entirety of the whole property. They're not limited to where they think the easement might be. They can go in buildings, they can go anywhere. They can conduct invasive surveys without limitation, without duration, limit to duration, frequency, place, activity. It's an incredibly extreme.
Is this the appropriate proceeding to challenge the right of condemnation? Wouldn't the better proceeding be the permitting and licensing process rather than kind of a countersuit on an injunction for the right of entry?
So I'm not challenging condemnation. I'm stating as a matter of fact, when they filed this lawsuit, they did not have the power of eminent domain, period, full stop. So it's not even something to challenge. They don't have it, which makes it even more egregious. They're not the Department of Roads that have it by their very existence as a public governmental entity. That's a major distinction in this case. They are not the same.
So they're allowed to survey to enter under the statute to determine the direction and depth of the pipeline, proposed pipeline. How long would that normally take?
They claim that they're never pinned down, and they claim that it won't take long or it won't be that bad, maybe a couple of days. But what they say might be or might be typical doesn't save the language which allows anything, anytime, invasive or otherwise. I'm fighting the language.
Well, Cedar Point involved a California law that allowed entry over the landowner's objection for up to 3 hours a day, 120 days a year. This seems like more of a one-day deal, right?
How it might actually be used by a company operating in good faith has nothing to do, and it doesn't save the language that is limitless.
Well, but Counsel, you're making a facial challenge here, right?
There is no difference in this type of analysis if undertakings. If there's a taking, it doesn't matter if it's facial or as applied.
Well, if it's a facial challenge and they can come up with some survey that doesn't go days or doesn't sort of go to the same extent as they did in Cedar Point, doesn't that matter?
It doesn't matter for our challenge. That's maybe the minimally invasive. Maybe they say, hey, this isn't going to be that bad, but they haven't solved the little problem that they're not a condemnor and they're not vested with condemnation rights. Therefore, they can't do pre-condemnation activity. That's the major threshold. The minimally invasive is just another problem that they have.
Is that even involved in this appeal, whether they're a common carrier with eminent domain powers? It seems like we're getting a little ahead of ourselves.
Well, it's not in this appeal, which is the problem. It's because it's not in the statute. And it's because it's not in the statute, again, it's purely weighing convenience of a startup company. I could start Bryan Jorde Pipeline tonight and come to you and get on landowners' lands without their say-so, without their approval. So,
can you cite any case that has extended Cedar Point to a pre-condemnation survey access statute like this that rules your way?
So you are the third case in the country to look at this. I've been fortunate to handle the other two. But the difference there is that the statutes in North Dakota and South Dakota were very different because they required the entity doing the pre-condemnation survey be vested, quote, vested with the right of eminent domain, and they had a public use test within those statutes. That's why this statute is completely different. There is no public use threshold. There is no vesting requirement. And so to directly answer your question, in North Dakota, the statute that was challenged, they only have one in the whole state for pre-condemnation survey. So it covered the government and everybody, which made it much more difficult for me to say, hey, everything is out. Whereas here
Assume
it's
we need to go
narrow.
to the argument of whether or not, the eminent domain, let's put that aside. Assume for purposes of tonight that isn't going to be the issue. What would happen to all of our jurisprudence if we followed your path? Because it seems to me when I look at Cedar Point case, their statute was way more intrusive than the statute here. So what would that do to our jurisprudence?
I think this is much more intrusive. There was a limitation to place, a limitation to time. They couldn't conduct activity anywhere except for an agricultural production facility.
Okay, let's just assume 3 hours a day, 120 days a week. You got to give me that. That is incredibly intrusive.
It is.
Compared to, and let's assume, for argument's sake, that a survey can be done within a reasonable period of time. Doesn't that make Cedar Point quite a different case to be relying on?
Well, I think what the example you're giving me is what could happen versus what we know did happen. The reality versus a possibility. And the language, I'm fighting the language. And the language allows access 24/7, anytime, forever. There is no end date on the temporary injunction they seek. And they only have to get it one time. If they go out there to allegedly do an innocuous survey, but realize they have to do a geotech survey, they don't get another injunction.
Well, you could maybe have another day in court. I think it's the North Dakota case where the landowners argued that Summit has perpetual easement. And their interpretation was something like, but when a project is complete, that isn't perpetual. So wouldn't common sense dictate that if it went on ad nauseum, you could have another day in court?
Well, once the injunction is granted, what more is there to do?
I mean, you can always go in and ask to modify an injunction. We have those kinds of cases all the time, or to terminate it, right?
I could ask to modify it, but now we're the horse has left the barn now. I'm talking about on the front end, that this is an extreme right to give a private company the right to invade someone's property against their will for the mere convenience of looking around.
But again, as some of the other questions have suggested, it strikes me this is different from Cedar Point. So Cedar Point talks about background restrictions. There is a history of surveyors being allowed to go on properties, on private property, for a limited time to conduct surveys. The idea of union organizers to go on private property, Generally speaking, even the National Labor Relations Act, our federal labor law, and that's only been around since the 1930s, doesn't allow that.
True. And this statute's only been around since 1995. It's hardly a long-standing background principle steeped in the history of Iowa. And the test is, would a reasonable landowner believe that when they purchase property, they are subservient to the desire of any possible company to want to kick the tires, even though they don't have eminent domain powers?
So let's talk about the issue of remedy. Let's assume that you were right and that this was a constitutional taking. How does that impact the request for injunctive relief? Because even if you were right, it doesn't give you an absolute power to exclude the surveyors. It would just give Mr. Kasischke the right to compensation for the taking.
If they have the power of eminent domain, which they have to apply for and be granted through the Iowa Utility Commission. So it's not a certainty. I grant you, if they become vested with the power of eminent domain, then obviously they can enter to do a minimally invasive, innocuous, superfluous survey. So the key is, if you're not going to go with
so
that,
is this just a timing issue? So, I mean, you frame this as a facial challenge to the constitutionality of the statute. And if I heard you right, I think what you're just saying is, really, this is just a procedural issue, and once they've been granted the power of eminent domain through the proper channels, getting the permitting, et cetera, then you would concede that Summit does have the right of entry to do a survey?
I'm saying an entity that it does in fact have eminent domain obviously can enter the property for whatever they've condemned the interest in. But for pre-condemnation to be exercised by someone who doesn't have eminent domain, isn't vested, hasn't proven to be a public use, that is unconstitutional. I see my time's up unless there's any more questions.
Any more questions from the bench? Okay, you may be
Okay,
seated.
thank you.
Mr. Koopmans.
Thank you, Chief Justice. May it please the court, and may I just say I agree with you completely, Chief Justice. This is very cool. I want to start by just kind of clearing the deck and framing what the takings issue is and isn't. Just as the court has talked about, there is no fight here in this case about public use, about common carrier, about the right to take ultimately an easement on this property. Also, this is a facial challenge, and it is about as simple as you can be. Under this court's jurisprudence and the U.S. Supreme Court, unless they can prove that the statute is unconstitutional under any application, under any set of facts, they lose that challenge. In fact, this court has even kind of reframed, in some cases, that facial challenge, which is to say, if they do not prove that it's unconstitutional as applied to them also, they don't even have standing to go and challenge the face of the Constitution. So we have a statute here which, any set of facts, you could say, is it unconstitutional for a survey incident to condemnation proceeding to go onto the property and just look for the metes and bounds to make sure that the easement that they're going to seek is where they say it is. That's about as simple as it could be. And in Cedar Point, the court didn't change anything about takings law, didn't change Lucas. And in Lucas, Justice Scalia said, of course, the government cannot take what the property owner does not own. And that's where the background principle standard comes in. If you're...
So, Counsel, I have a question on that point. So, is there a longstanding background principle to give this sort of right to a non-governmental entity?
I believe the very first survey access statute that Iowa passed was in 1851, before our current Constitution was even ratified, which was for a railroad company. And so it's not a pipeline company, and nowhere in any of the case law have I ever seen this kind of background principle, which is, again, almost like a principle that is not specific because it inheres in the title of the property itself, that it is for a carbon capture pipeline company to have survey access. That's not how background principles work. And if you look at the authorities we cited in our brief, Justice Cooley has said far back as 1868, the North Dakota Supreme Court relied on this, that survey access for incident to pre-condemnation is a background principle. In his tort treatise, which we also cited in our brief, he analogizes it to a license. The surveyor has a license to go on the property, and in that same treatise, he analogizes that to the administrative officer who has a license, like a police officer, to go on the property when they find it necessary. It's a same type of thing. So that license to conduct a pre-condemnation survey is inherent in the title, and it is a background principle.
Quick question. You asking for permanent or temporary injunction?
We are asking for, and how our rules, technically our rules don't use the word permanent. They divide out between an injunction and a temporary injunction. A temporary injunction being one that you get before the final merits of the case. Here, we got the injunction after trial, and so it is for a limited purpose, which is under the statute, to go and survey to find the meets and bounds and the depth. And obviously, if you exceed that, some unreasonable thing, if you just keep coming back and back, and no reasonable surveyor would do that, they could go to court and say, we have violated the statute. And I guess we have not violated the injunction, because the injunction is only enjoining them from stopping us from going on the
What
statute.
about tenants? Would this have any bearing on them, or do they have to go to court again?
The tenant is not part of this. Well, the so-called tenant is not part of this case. And the survey access statute just says you have to serve people who are in possession, who are on the property. And as the district court found, it's not even clear what kind of lease for when this person has. So we don't even really know what the tenant's rights are, meaning with respect to this property. And that was a factual finding as far as not only the evidence that was admitted, but the candor of Mr. Kasischke.
If we were to hold that this statute was an unconstitutional taking, what effect would it have on all the other Iowa statutes that allow survey access for private and governmental entities?
Because the background principle is broadly defined, not specifically defined, not defined for a specific pipeline company, it would either be an on or off switch. Either we all get survey access or none of us do. And so if Summit doesn't, because the legislature has set out a process for getting eminent domain, doing surveys. If we don't have it, then Iowa DOT doesn't have it. Railroads don't have it. Electric utilities don't have it. Then you are condemned. Then you are actually putting people through the process of actually condemning just to go on and do a short survey, which again is not something that we have to do, because that is a background principle that's been recognized since at least 1851 in this state.
Can you address the differences between the statute in Iowa and the statutes in North Dakota and South Dakota with respect to vesting?
With respect to vesting, Your Honor?
Great.
So in Iowa, they actually, I don't know if it's more protection, but they actually, the legislature has the authority to give eminent domain power. They have the authority to allow for surveys. Iowa has tied together eminent domain authority with not only just the public use requirement, but also putting in the Iowa Utilities Board the decision of whether this is actually kind of the right path, the right place to go. And so Iowa has kind of given more protection to landowners and to make sure that pipelines are going and sited in the correct place. It has no constitutional difference, because under the background principle, the state has the power to give that survey access. On the supercritical issue, I just want to touch on that briefly. So,
I'm interested in that. How is a supercritical fluid actually a liquid?
to all of us, it's a liquid. To the very intelligent, perhaps to the chemist, it's something different. And this court and the U.S. Supreme Court has always said that terms should be interpreted in their ordinary or customary, not scientific meaning. Justice Story in 1824, interpreting a tariff act, this is 200 pounds of tea, said that exact phrase, that we don't go and look to the, people aren't chemists, they aren't botanists.
But I look at that diagram that Mr. Jorde provided that's in the record, and it looks like there's 4 possible states. There's liquid carbon dioxide, and then when you get it really hot and it's more dangerous, it becomes a supercritical fluid. So, you know, why isn't that the analysis that we should follow? That there are 4 states and the supercritical fluid is not the same as the liquid.
Well, chemists actually don't even agree on whether there are 4 different phases. They say it's between phases. So I guess maybe that's a state. But the question is, what is? You know, the legislature is its own lexicographer. What did they mean in context by liquefied CO2? And it's important to understand that in context of why we even have Chapter 479B at all. And the only reason why we have that, if you look at Chapter 479, it covers the waterfront. At least it seems to be intended to cover the waterfront of all pipelines. Any pipeline that is a liquid, that is a solid, a gas, or a liquid other than water. So it covers the waterfront other than water. In 1995, the legislature pulled out hazardous liquids from 479B, and that's because the Eighth Circuit in Kinley versus Iowa Utilities Board said that 479 is preempted to the point where it says that the Utilities Board can govern the safety of pipelines. Safety is completely preempted and off limits for the states and for local agencies, and is left purely to the United States Department of Transportation. So at that time, when they moved everything in 479B, the only CO2 substance that the DOT regulated was supercritical CO2. That's the only substance they have ever regulated, because those are the only kinds of pipelines that exist to transport CO2 by and large, because those are the ones that are used for enhanced oil recovery, and up until now, that's all there was. So now if you go, so we are tied inextricably with the Pipeline Safety Act. And if you go to 49 USC 660-102, it says that the Secretary of the Department of Transportation is supposed to create safety standards for CO2 that is transported in a gaseous state and a liquid state. It says nothing about supercritical. But still, to this day, the only thing that PHMSA, the regulatory agency underneath DOT, the only thing that they regulate is supercritical CO2. And to kind of get into detail about how complicated these, so nobody's disputing what supercritical means in terms of the pressure at 88 degrees, or a pressure above 1070 psi and a temperature above 88 degrees. But the labels that people use for that, and if you look at the materials, even their experts, they criticize our experts. They criticize our witnesses who use dense phase and supercritical interchangeably. But PHMSA also uses them interchangeably. So what are the labels here? Again, we're dealing with language, not science. And so what are those issues? And then we also have...
Before you get to that, I want to raise a related question, which is this the right venue or proceeding to litigate that question of whether or not this is carbon in a liquid state versus supercritical state? Meaning, if IUB goes through the permitting process, or I'm sorry, if Summit does and IUB determines that this is a pipeline within the meaning of the statute, maybe we need to make that decision in reviewing the permit versus this kind of pre-condemnation survey access.
They have, in fact, made that decision. They've rejected this exact supercritical argument. And I guess just a distinction on what you were saying, Justice McDonald, I don't know if it's the right place or the wrong place. It's not really a factual issue. Ultimately, it's a legal issue. I mean, there's no dispute about the pressure and the temperature at which this will go through, kind of. And very quickly, just again, to go back to how complicated this is, I want to just read what their expert said at appendix page 145, because he listened to the testimony about what kind of CO2 we were going to be flowing, listened to testimony in North Dakota and South Dakota, what kind of CO2 was going to be flowing through the pipeline. And he said that he hasn't seen evidence of how Summit can keep the pipeline above the critical temperature of 88 degrees. Absent such important information, and because of the confusion in testimony wrongly intermixing dense phase to imply only supercritical phase, I can only conclude the proposed pipeline system will be largely operated in liquid phase with temperatures below 88 degrees. So that's how dense or complicated this gets. And so now back to the question, who is best in at least the initial stage to make this kind of determination, not about the science per se, but about what that language means in the industry. And I think that is the Utilities Board. And so I think deference would be owed to that determination about what liquefied CO2 means.
Counsel, could I ask you about the injunction question? It seems from the briefing that your position is basically as long as the statutory requirements are met, that an injunction follows pretty much automatically. But I'm somewhat troubled by the language of the statute and why it uses the word may, which would usually suggest some discretion or more, maybe even equitable principles should govern. And if you could just address that.
So it can be self-executing, but of course it says may, and we're always dealing with controversial issues going on somebody's property. It's sensitive. And so I think the best way we can make sense of that language is just to say, you don't necessarily get an injunction if there isn't any indication that they're going to block you. But the refusal here, the kind of credibility determinations that the district court made on the bench with the plaintiff there, I think get you over that hump to say that there is an injunction. An injunction is warranted. On the mailing issue, if there are any questions, I can just quickly hit that. He did sign for it. He received it.
Yeah, but you guys did something like second round, delivered to addressee only. Isn't that kind of an admission that your prior attempts may not have complied with the law?
It's counsel's attempt to try to save money so that we weren't here arguing about it. That's really all that was. They say that it wasn't correct, let's do it again. But if we go back to the beginning, we did do it correctly. If you go to the post office website, you can give them instructions. Please deliver the box to the garage. Please go around back. At one point in time, delivering it to the addressee was like that. Now, restricted mail, in the very definition of it, you pay for that. It is to deliver it to the addressee only. In the case they cite bus, if you look at it, they chop the quote short. It didn't just not have restricted or delivered addressee only on it. The postage on the stamp or the postage on the envelope wasn't enough to actually pay for restricted mail, and it did not, in fact, get delivered to the addressee.
But did your client ever provide the fully executed return slip?
To the plaintiff or into the record?
Well, I just didn't, from my review of the record, it looked like maybe there never had been the fully executed return slip provided to landowners.
There is, Your Honor, and I will provide you a cite. Well, it is in the appendix. It's, I believe, Exhibit 6. And his signature is on that, and that's cited in the brief. And at trial, he declared that he did not, emphatically said, no, I did not get it. No, I did not get it. He was then presented with his signature in the return slip, and he said, it appears to be my signature. And obviously, you can't tell from the transcript how the mood changed, how his attitude was, but I can tell you that is where the adverse credibility determinations come from. Thank you.
All right, we'll try to get through this. The statute is silent on the relevant standards for injunction, and the equitable principles do apply, and there's no proof that of irreparable harm will ensue, and the transcript is full of that. They have hundreds of more permits to get, trial transcript 133 to 134. They don't have state routing in the other states that they have to have, so they should be denied an injunction on that basis. The tenant was never served, period. That's a stone cold winner for us.
I asked Mr. Koopmans a question, kind of leaned on him a little bit. Let me lean on you a little bit. What could they have done more? My review shows that the U.S. Postal Service had a return receipt and tracking. The first receipt has your client's signature on it, and then your client refused the second and third. Is that right?
There's no evidence my client refused it, and that's the problem with deliver to addressee only, when they're not tracking who they actually delivered it to. And you were spot on with the first attempts were inadequate. And the key quote of the whole night has been they tried to save money. And that's the problem with everything that brings us here today of these pre-condemnation surveys and wanting to get out there before they actually have done the work to get eminent domain. But I want to focus on the tenant. The tenant 100% did not receive notice. It's undisputed. We named the tenant. We told them there was a tenant prior to summary judgment. That's in the record transcript. The trial, or the summary judgment, or pardon me, the trial transcript on page 8, 55, 76, 79, 80.
Did the tenant, why wasn't he called as a witness at trial?
We don't have a burden of proof. That's why.
Okay, why didn't your client provide any evidence he had ever paid rent? Any rent payment over the 9 years?
The evidence is sworn testimony under oath, which is not inferior to a deposit slip. And his sworn testimony was named the tenant, trial transcript page 146. He said the tenant was on this land in question, that's Doc 130, summary judgment affidavit. And then I specifically asked him at transcript 147, lines 6 to 18, about the lease terms for your property in question in this lawsuit. He named it-
The trial judge who heard him testify live and observed his credibility made some determinations. He wasn't credible, and she made a finding that there was no tenant on this land that required additional notice. What weight should we give that?
None.
Why not?
Well, I frankly haven't the foggiest idea how she would come up with that
Oh, wait a minute.
determination.
Give a judge no, I mean, when it says right in there in her order, she found credibility, I think the words were not credible, disingenuous, and at best evasive. And you're asking this court to not give that any consideration? Wouldn't that change jurisprudence in every area of the law?
No, I think the weight, certainly give it consideration. But this gentleman has a sworn affidavit, which wasn't attacked, that gets us to the same point. He testified under oath, but it's their burden. It's their burden. They didn't serve one interrogatory. Do you have a tenant? That's their fault. They did go to the FSA office, get a Form 578. It shows the operator is the tenant. That's publicly available. They did nothing.
Well, they serve the owner. I'm not sure it isn't your client's burden to show that there's someone else that was in possession. But anyhow, it just strikes me, if I'm thinking about it, if I had a tenant in possession of my property, I would have some piece of paper I'd be able to bring into court that would show that or support that, right?
People can try cases lots of ways. He swore under oath. He said it in an affidavit. They did nothing to follow up with it. That's their fault. It didn't serve the tenant, period. End of story. If I would have said, who's your tenant? I don't know. Well, what does he look like? Well, I don't know. He named him a 9-year, year-to-year lease, cash rent. Is there any real dispute? There's not. They're trying to cover the saving the money defense by not getting the tenant served. And the statute specifically puts the burden on them to send certified registered notice to the tenant. If just in the last minutes here, I want to correct a bad cite on page 27 of our reply brief, paragraph 40. The cite should be to Doc 30, paragraph 17, and trial transcript 145, line 17 through 146, line 1. That's important because it's the only and undisputed evidence in the record that it is not within the landowner's traditional legal sense or the landowner's understanding that a background principle is a for-profit private company without eminent domain that can take away their right to exclude. That's the only evidence, and it's uncontroverted. So we ask that you reverse and remand on the issue of the injunction, find the survey unconstitutional or the statute, and if you don't find it unconstitutional, narrow it like South Dakota did and make it clear that they cannot do anything more than minimally invasive surveys, no innocuous, no below ground surveys. Thank you for your time. Appreciate it.
Thank you, counsel. The State of Summit Carbon Solutions versus Kasischke is hereby submitted and court is adjourned for the evening. Thank you.